Okay, so we would like to start with a welcome to everybody. Welcome to the Center for the Humanities in the Public Sphere in the College of Liberal Arts and Sciences at the University of Florida. My name is Barbara Mennel and I'm the Rothman Chair and the Director of the Center. You are attending the first speaker of our annual speaker series entitled Transforming Institutions. And this is the third year in which we are taking serious the second half of the name of our center, the public sphere. We are asking what are the forces that shape the public sphere and how do the humanities help us think about it? 2 years ago, we started this annual series on the question of the topic of the public sphere by first probing race and the promise of representation 2 years ago. And then last year, we addressed data and democracy. This year, we are engaging with scholars who present a deep and research-based look at institutions that are in the crosshairs of current public debates, from reproductive health, health disparity and mass incarceration, to public monuments, preservation of African American heritage, and the university and humanities scholarship itself. We will add a couple of links in our chat before we proceed, including the program of the entire series, Transforming Institutions, and our other series that aim at public engagement and undergraduate students. And now I will begin. Our speaker today is Michele Bratcher Goodwin, and she will give her talk. During the talk or at the conclusion, you please post your questions in the Q&A and the chat, and then we will read them after the talk and she will respond. This is a 1-hour event, so it's pretty short, so do not hesitate to post your questions when you think of them, and we will come back to them at the end. Michele Bratcher Goodwin is the Chancellor Professor at the University of California, Irvine, and the founding director of the Center for Biotechnology and for Global Health Policy. She's the recipient of the 2020 Distinguished Senior Faculty Award for Research. Her books include Policing the Womb, Invisible Women, and the Criminalization of Motherhood from 2020, Biotechnology, Bioethics, and the Law from 2015, Baby Markets, Money and the Politics of Creating Family from 2010, and Black Markets, the Supply and Demand for Body Parts from 2006. Professor Goodwin's constitutional law scholarship appears in or is forthcoming in the Harvard Law Review, California Law Review, Chicago Law Review, Cornell Law Review, Michigan Law Review, New York University Law Review, Northwestern Law Review, University of Pennsylvania Law Review, and the Yale Law Journal, among others. She's also the host and executive producer of the podcast On the Issues with Michele Goodwin at Ms. Magazine. So thank you for being here. Thank you for being here, Michele Bratcher Goodwin, and please take it away.
Thank you very much for the invitation to join you and the community at the University of Florida. It's really a pleasure to be with you. And let me just say that the topic of the talk, of course, and sadly, couldn't be more timely given the dynamics of what we see today emerging in terms of questions about states' authority to interfere and intervene in individuals' choices during their pregnancy, or as many are beginning to use the language of reproductive freedom in conversation with speaking about reproductive rights and reproductive justice and reproductive health. And so much of my talk today is really rooted in questions about pregnancy and state power and the prosecution of what has become known as fetal endangerment. Just very recently in Lawton, Oklahoma, a woman was found guilty of first-degree manslaughter when she had a miscarriage, at 17 weeks of pregnancy. Now, this would have seemed to be an extraordinary thing that would not happen even a century ago, let alone 50 years ago. But in a time of heightened attention and awareness to women's pregnancies and the policing of those pregnancies, then at least from my perspective as a researcher in this space, it's not so surprising. My book, Policing the Womb, Invisible Women and the Criminalization of Motherhood, is a book that was produced, it came out last year, but it was a book that spent 10 years in the making, because from 2010 through 2013, I noticed this dramatic uptick in the ways in which states were legislating against reproductive health rights and justice. The first aspects of that might have caught people's attention were issues related to abortion. But my concerns are broader than abortion. Abortion is one spigot, if you will, or it's kind of one link on a series of links that make up a wheel of reproductive rights. And so let me talk you through a bit of my concerns about these times. For all of the important and urgent attention to reproductive rights focused on preserving abortion access in an era of political and judicial backlash, far less advocacy is devoted to protecting the liberty and dignity interest of women who wish to remain pregnant. That is, abortion rights occupy the primary focus of reproductive privacy, advocacy, and the movements that ground that in the US. Now, to be clear, I should say that the new Texas law, SB 8, which prohibits abortions after 6 weeks of pregnancy, a time in which most people would not even know that they're pregnant, and that deputizes citizens to go after, hunt, surveil, and sue fellow Texans who aid and abet a person in terminating a pregnancy, and then to a bounty of $10,000 reward in the process and the receipt of legal fees. It is draconian. It is inhumane. It does not fit with a human rights agenda. And so even though my talk today is not about abortion and in many ways critiquing the abortion rights movement, it is not a critique of abortion rights themselves. It's important to know that a person is 14 times more likely to die carrying a pregnancy to term than by terminating it in the United States. In Whole Woman's Health v. Hellerstedt, a 2016 opinion from the United States Supreme Court, Justice Breyer wrote the opinion, and he directly quoted the empirical evidence that's been amassed over time that shows that pregnancy is far more dangerous than an abortion. That is to say, if a person is doing everything possibly right in the United States, she's 14 times more likely to die by carrying that pregnancy to term than by having an abortion. The World Health Organization has suggested that an abortion is as safe as a penicillin shot, and it is. And in Whole Woman's Health v. Hellerstedt, Justice Breyer and the others who are in the majority in that decision from 2016 outline any number of other common kinds of surgeries that are far more deadly than terminating a pregnancy. But my point here is that as dangerous as it is in the United States, ranks between 50th and 54th in the world, for pregnancy safety. That is to say that a person is far more likely to die by carrying a pregnancy to term in the United States than in Saudi Arabia or Bosnia. Texas and Louisiana are considered the deadliest places, not just in the United States, but the entire developed world for a person to be pregnant. That serves as a backdrop. And nevertheless, at that backdrop, individuals who choose to be pregnant should be able to do so with dignity and integrity without the prosecutorial intervention of the state. But part of an argument that I want to make here is that part of the failure to see a broader nuance with regard to reproductive rights actually meaning something about multiple rights within the reproductive space is that so much of the attention had for so long been on abortion. And in many ways, one could see that in the period leading up to Roe v. Wade, in the dramatic deaths of people who died, women who died in motel rooms atop of white sheets that had been bloodied. Parents coming home and finding their daughters dead in bathtubs. Husbands coming home and finding their wives dead on the dining room table. People telling stories about barely surviving what have been described as back alley abortions, which were not always in back alleys. Sometimes they were in places that looked like legitimate medical establishments. But the point being, all of this underground activity, and some of it in very powerless and dangerous types of conditions, shaped what became the backdrop to Roe v. Wade. And that horrific backdrop was something that hit home with a number of families. Perhaps that's why Roe v. Wade was a 7-2 opinion, with 5 of those 7 justices being Republican appointed, and Justice Blackmun, the person who penned the decision itself, being appointed to the court by Richard Nixon. But one of the aspects of treating reproductive rights as an issue that is only about abortion means that there are many other spokes on the wheel that can be overlooked. And that includes matters of sex education, it includes carrying pregnancies to term, and so much more. In my book, I tell the story of a person named Captain Strzok. The case of Captain Susan Strzok versus Secretary of Defense really advances my argument. Captain Strzok became pregnant during her Air Force service in 1970 while stationed in Vietnam. The United States Air Force Regulation 36-12 prohibited pregnant women as well as mothers from serving in its military division at the time. The Air Force presented Captain Strzok with an ultimatum: terminate the pregnancy or leave the military base within 48 hours. In the years before Roe v. Wade, military bases were among the few places where a woman could legally obtain an abortion. So another aspect of the conversation that deserves our sophisticated rather than reductive treatment is that in the United States military, before Roe v. Wade, it was legal to have an abortion. And in fact, in Captain Strzok's case, the military wanted to force her to have an abortion or leave the military. However, Captain Strzok did not want an abortion, which the military demanded she have. Instead, her choice was to continue the pregnancy and not suffer the stigmatization and repercussions of both losing her job and livelihood for making that decision. Seeking a compromise, Captain Strzok offered to surrender the child to adoption after its birth in order to remain in the military. Imagine being put in that position because the state is policing your pregnancy, that you would have to surrender the child that's born from you for adoption in order to serve in the military. The Air Force actually rejected this option and discharged Captain Strzok. She appealed the discharge 7 times, including to the Secretary of the Air Force, and in each instance, she lost. The military insisted that she have an abortion and terminate her pregnancy. Eventually, Captain Strzok appealed her case to the District Court for the Western District of Washington, claiming that the Air Force regulation violated equal protection of the law. She argued the regulation constituted an unconstitutional sex-based classification and, as applied, infringed upon her right to privacy. According to Captain Strzok, this infringement interfered with the ability to conduct her personal life. She also argued that the regulation infringed on her right to a free exercise of her religion because she was Catholic. The district court held that the Air Force regulation concerning pregnant officers was reasonable and also constitutional. So here we have, even before Roe v. Wade, a district court saying it's reasonable for the military to present an ultimatum of have an abortion or leave the military within 48 hours. The court therefore dismissed her motion, and Captain Strzok's application for a stay pending appeal also failed. That is, when a stay is that let's put an injunction, a hold on this case while I appeal it up to a higher court. And a team of 4 lawyers from the American Civil Liberties Union, including Ruth Bader Ginsburg, appealed Captain Strzok's case to the Ninth Circuit Court of Appeal. I'll just spare you so I can go on to the rest of my talk that she lost again. And the military ultimately withdrew its demand because the case of Roe v. Wade was coming before the court, and Roe represented something more, not just about abortion rights, but also free autonomy with regard to a person's pregnancy. But what has this meant over time? And why is my book called Policing the Womb? Well, I think that when a state intervenes and interferes with a person's reproductive freedom to be able to terminate a pregnancy, then that is policing. And certainly we see the surveilling that the state of Texas is now incentivized by its SB 8 legislation is clearly policing and surveilling now, not just by the state, but the state deputizing citizens to do so. And we could talk about that, the very disconcerting aspects of that, including what it means about free speech. But I'm also deeply concerned about another space of policing that is taking place, which I began my talk with. In the wake of treating reproductive rights as only about abortion, we miss so many other aspects of what it means when the state is interfering with a person's freedom of reproductive autonomy. This means that we pay very little attention to the eugenics movement in the United States, in which states were allowed, and I say lawfully because the Supreme Court allowed it to be so, where states forced people, particularly poor people, almost exclusively poor people, to be sterilized against their will as the United States was on a campaign to make a fitter and better society. Now, for some of you, you might say, well, this sounds like Nazi Germany. Well, you would be right, because the Nazis in Germany borrowed from the United States case law, Buck v. Bell in 1927, and borrowed from the very law that the Supreme Court was reviewing in that case, a Virginia compulsory sterilization law, a law that made it such that the state could round up literally any person that it thought to be unfit to be in its society and forcibly sterilize that person such that they would never reproduce again. In the case that went up before the United States Supreme Court in Buck v. Bell, a 1927 case, is a case that involved a poor white girl who was 16 years old and had been raped by her employer's nephew. She had a pregnancy as a result of that. In the state of Virginia, that was considered unfitness. You could be unfitness, largely it was because of your poverty. In her case, her mother was alleged to have been an alcoholic and possibly a sex worker. Carrie had been poor, and the state considered her a quote unquote imbecile, even though there were never any findings about her intelligence as being somehow diminished. In its ruling, Chief Justice Oliver Wendell Holmes said 3 generations of imbeciles are enough. The power that the state has to impose vaccination is broad enough to cover cutting the fallopian tubes. He said, rather than to allow degenerate offspring from continuing their kind, society is better off from making sure that those who are manifestly unfit, and those who are manifestly unfit, he figured would be people who might engage in crime somehow thereafter, but that society was better off by making sure that those people had no place in our society. Now, how the court could predict that the little girl that Carrie Buck had would somehow grow up to be a degenerate, that she would grow up to be criminal, well, this was all a part of eugenics platform, which then allowed for the forcible sterilization of tens of thousands of Americans. And the Nazis in Germany picked up from this. They actually came to the United States and studied how the United States was carrying out its eugenics program. A reproductive rights framework that's broader then pays attention to this, but it also pays attention to other aspects of reproductive freedom. And also it pays attention to what is happening today and what was happening decades ago. And that is the criminalization of women during their pregnancy. Now, I could walk you through various other aspects of what a reproductive rights framework should be, but let me just say this. Given that this program has paid attention to matters of race in the past, you know that when we talk about civil rights, that's not just Brown v. Board of Education. You know that a civil rights movement affects education, housing, employment, where one can actually walk to in a park or not, and many different other aspects of life. It's not just one thing. And so here, what I want to just share is that really what the book takes us through is an ethnography then of the various instances in which, and these instances serve not to be episodic, but actually to stitch together what has been more systemic campaign, particularly targeted at poor women of color in the last 30 years and their criminalization. So it tells the story about the Medical University of South Carolina and a campaign that it launched to encourage poor women of color to come into the hospital for prenatal care. What these poor women did not know is that the hospital was already coordinating with local police and with prosecutors such that they would take these individuals' urine samples and turn them over to police. What they were looking for: who amongst these women have ingested crystallized cocaine during their pregnancy? Interestingly enough, their program was only about crystallized cocaine. It wasn't about the myriad other illicit or prescribed medications. It was very racially targeted. In fact, of the dozens of women who were arrested as part of this campaign, literally dragged out of hospitals in shackles and chains and bloodied gowns after giving birth, all were Black, even though the rate of crack use during pregnancy is not distinct between Black and white. And in fact, through court records, what we know is that this campaign specifically left out white women who used crystallized cocaine during their pregnancy. And the only one white woman that was included amongst the Black women who were prosecuted and arrested was a woman on whose medical chart Nurse Brown wrote, "Lives with Negro boyfriend." Presumably, that was what it took if you were white to be included in this racialized program. Now, I also talk about other cases, including where I have been an expert witness, such as in the case of Bebe Shui. Bebe Shui is a person who was prosecuted for first-degree murder after an attempted suicide in the state of Indiana. Now, it's worth noting that in the state of Indiana, it is not illegal to attempt suicide. But it's worth noting that in the wake of policing pregnancies, all bets are off. The rules change. And in the state of Indiana, after Bebe Shui had been left on the ground pleading and begging to her boyfriend for him not to leave her, in her anxiety and depression, she ate 6 packets of rat poison. As a result of that, and a friend found her, very aggressive measures were taken to save her life. Doctors later testified that perhaps some of the very aggressive efforts that they took to save her life may have actually affected the fetus. At any rate, the fetus was born, delivered, and then died several days later. This is what the prosecutor said in justification of their prosecution of Bebe Shui. Had they been successful, and what the prosecutor was looking for was a minimum of a 40-year sentence for Bebe Shui after this attempted suicide. The prosecutor claimed, well, this wasn't really about Bebe Shui attempting suicide. This was Bebe Shui trying to have an unlawful abortion. I could tell you about cases of women being arrested for falling down steps and simply trying to make sure that their health was preserved, and telling nurses and doctors, I fell down steps, I am pregnant, I want to make sure my pregnancy is okay. And that being sufficient in the state of Iowa for a woman's car to be surrounded by police to take her in, incarcerated for 3 days while prosecutors tried to figure out what to charge her with. I could tell you about cases like Lisa Epstein, a mother of 5 who just simply wanted to have a vaginal delivery versus a C-section, and her doctor sending her a letter saying, unless you come in today, you leave me with no other choice than to have police drag you in here. Fortunately, Lisa Epstein was not a woman of color. She was white, she was in the state of Florida, and she was middle class, had a lawyer, and her lawyers contacted the doctor, and the doctor then apologized. But this should not be the backdrop of pregnancy today. I could tell you many other stories. In the state of Alabama, in recent years, there have been more than 500 women who've been caught up in a dragnet that was never intended to be about pregnant women. In the state of Alabama, there is a law that provides for that provides for the protection of children in cases of individuals, was intended to protect children in the case of individuals turning their homes into methamphetamine labs. In a lot of ways, I think that prosecutors had a male face on this when the law was initially enacted by lawmakers. Lawmakers were thinking about this through a male lens, since in Alabama, empirically, people who are more often to turn their homes into meth labs happen to be men rather than women. But the prosecutions that have resulted from this child endangerment law in Alabama have been women, and here they've been largely poor white women. And the plea deals that these women have taken have been up to 20 and 25 years, even in cases where there's been a healthy birth after the prosecution or even before the prosecution. It's these kinds of cases and many others that give us evidence of the policing of reproduction, the policing of the womb that's taking place throughout the United States, where really there is no place where a woman is safe, really, from this type of policing, even in the state of California. In recent years, and I'll close with this because I know that we'll have Q&A, in the state of California, where the constitutional right to privacy with relation to reproductive rights is enshrined in the state's constitution. And yet, within the last couple of years, there was a woman who was prosecuted in the wake of having a stillbirth in the state of California. That case has been dropped. As well, we have evidence, and recently there was a documentary made about coercive sterilizations taking place in California jails and prisons. So that even in a state of California, which provides reproductive health choices and rights and support for individuals, including for those who want to terminate a pregnancy, get STD screenings, and so much more, it's a state that also hasn't been free from the same kinds of issues in which I'm talking about. And so across the country, we have seen women being targeted for arrest, threatened with police intervention in their pregnancies, and actually sentenced, including lengthy sentences for having miscarriages and stillbirths. Now, let me close with this. Some of you may be wondering, well, why haven't you heard about this? Why didn't you know about Carrie Buck and Buck v. Bell from 1927 when the United States Supreme Court legalized eugenics to take place in the United States years before it happened in Nazi Germany? Why have you not heard about the cases that involve doctors calling the police on patients or threatening to call the police on patients who are refusing cesarean section? And I should let you know, cesarean sections can be very dangerous for women, sometimes very necessary, but also risky. Why have you not heard about the cases of women being prosecuted for miscarriages and also for stillbirths in the United States? Well, largely because this is a history that involves poor women, and it's a history that has involved women of color. And in many ways, these have been women who are rendered invisible in our systems of criminal justice and in our systems when we think about protecting women's health rights and safety. So with that, what I'd like to do is open up the conversation for Q&A.